Tune in to Legal Affairs and You on Thursday, June 27 at 8 p.m. The discussion will focus on probates and letters of administration. Learn about application for grants of probate, execution of a valid will, distribution of estates, and more. 8 p.m. this Thursday on DBS Radio, hosted by the Ministry of National Security and Legal Affairs. Know your rights, know the law, know your ministry, know your procedures.
Good evening, you're live to yet another very interesting program, I hope. Tonight we have a full house. We have a very full house there, three wonderful ladies, very bright, well dressed tonight, and I know that the public is going to be very much happy tonight. And the last program we had that was very, very instructive, and tonight I can tell you it will be no exception. We are going to actually be looking at some areas tonight, and they can be characterized as vexing areas. And sometimes people die interstate as without a will, and a family member applies for letters of administration, and at the time people die, often having left a will behind, and the will has to be probated. The number of areas that we need to qualify here tonight, and we have three able individuals here tonight, three young brilliant attorneys. I can say I worked with them. Some of them I've taught, and I can say that they're very good at what they do. So tonight I want to actually begin by allowing my guests here tonight, our guests, our wonderful guests, to introduce themselves. And let me say good evening to our wonderful listeners, those of you who are listening from Dominica and overseas. I invite you to sit back, relax, and learn. As I've said before, and I want to reiterate for emphasis, a more informed citizen is a better individual, and a better individual leads to a better country, community, and of course family. So we're going to start with the Permanent Secretary in the Ministry of Legal Affairs and National Security, National Security and Legal Affairs, Ms. Joan Commodore, where we was also the Acting Registrar General, that's a big position, and the Deputy or the Assistant Registrar General. So let us begin with Ms. Joan Commodore. Good evening to you.
Good evening, Honorable Minister. Good evening to all our listeners, all the people that are tuning in, the people who have been following us faithfully from the beginning of this program. Good night to everybody.
Good night, everybody. My name is Nurea Sebastian.
Can you speak into the mic, please, a little louder, if you.
Good evening, everybody. My name is Nurea Sebastian. I'm the Acting Registrar of the High Court, Registrar General. Good evening to all of the listeners, and I hope that we will have a very interesting program for you, and you will learn a lot from what we have to say.
Good evening, everyone. Good evening, Honorable Minister. Good evening to the listeners and everyone tuned in tonight. My name is Kayan Tuse. I'm the Acting Deputy Registrar of the High Court, and I am looking forward to this program and advising or more informing the public of the topics of grants and probates and letters of administration. Thank you.
Okay, let us begin with the Permanent Secretary before we go to the Registrar General Acting and the Deputy or the Assistant Registrar General. Let us start Permanent Secretary. And what we have done over the years, you can recall, during the passage of Hurricane Maria,
yes,
that the location where the registrar or the registry, the civil registry, inclusive of the Supreme Court, operated was significantly damaged as a consequence. And there was a hoopla within the public domain, and it also created some concerns for the employees. And we, as a government, within the ministry, we proceeded to have done a tremendous amount of work to refurbish and to ensure that the staff members are more comfortable, the condition is more conducive. And not only that, because what we actually pride ourselves at insofar as the ministry is concerned and the government on a whole is concerned, is that we represent the interests of the people. We are in service to the people. So therefore, the people, when they come to access services within the various ministries or departments or agencies, they have to feel an environment of welcoming. Just give us an insight as to some of the work we have done over the years and to ensure that the civil registry, inclusive of the Supreme Court, is at a location that is welcoming to all.
Thank you. I always say that the registry encapsulates almost every aspect of your life. Your birth, your marriage, your death, your will, your deeds, your probate, everything. If you think of it, most of your significant life events are at one point or the other going to be captured at the registry, the Supreme Court registry. What you have at the registry, of course, is several registries in one, inclusive of the Supreme Court. And bearing that in mind, we suffered a lot of damage post-Maria. We ended up with issues with mold. The building, which already had, a fair amount of age on it, suffered a lot of damage. So when the Honorable Minister was able to secure the new building for us, the original contract was in the region of $3.5 million in terms of the amount of money that we had to spend. And of course, that is because we had to ensure that the building that we are putting up was befitting of the dignity of a court. And so we also had a lot of stakeholders that we engaged, inclusive of the Eastern Caribbean Supreme Court authorities, who actually came down to Dominica to do, some of the walkthroughs with us. So it was a lot of money, and we added things that we didn't have before, like, a mediation room, a robing room, and things like that we did not have before. We also made space for a library. There's a lot more space. It's more spacious. Just the ambience, everything is so improved. And the morale of the staff, it improved almost overnight. If you have been to the registry, you will attest to how different it is, how much more welcoming the atmosphere is, how much more spacious it is. Not forgetting that the Registry of Lands is also housed in that very same building.
Okay, well, thank you very much, and it's also more welcoming to the attorneys too, and they have room for the ropes and etc.
Elevators.
And elevators and
for our elderly patrons, they can access much better. There's an elevator, etc.
No, it's important to actually and speak about those issues, because you can recall those a couple months thereafter we were struck by Hurricane Maria, and there was a lot of pressure being applied on the government to house the court while people's homes were roofed. And I think we have been a long way. We have in actually addressing some of the fundamental issues, and to the extent to which we have been able to move to a situation where we have free courts at the Supreme Court level.
Yes.
And coming from civil and criminal. Now we have a court that can be used for a master's court.
Yeah.
And then we have a civil court and also a criminal court. And I think that is also something that we need to emphasize so the public can appreciate and understand that this government has always been consistent in trying to address the needs of the people and trying to be responsive to the needs of the people in every respect insofar as service to the public is concerned. Now, I want each of you to tell me something about yourself in terms of from a professional standpoint and how you have gotten to the point where you are currently are. And I will start firstly with UPS, and then we'll go quickly to the Registrar General and then Ms. Tuse.
I think one of the things that I would like to highlight about myself is consistency. Nobody, of course, is perfect, but I believe that I'm very consistent, and I'm constantly trying to improve on who I am and my performance. That is something about myself that I would definitely say.
Okay.
Can you speak into the mic, please? And yes.
Okay, this is Nuria Sebastian, acting registrar. I started off at the Attorney General's chambers. I spent a few years there, and then after that, I was at the legal aid clinic, and then back to the Attorney General's chambers, and then to the registry as the acting deputy registrar. And that's from 2016. I have been in the position of the acting registrar general from about November 2023. I quite enjoy the work that I do. It involves, assisting the public with so many different matters. As the PS said, nearly every aspect of our lives can be found at the registry. So this position gives me the opportunity to deal with so many different issues affecting the public.
Okay. Ms. Tusa?
Yes. Good evening, everyone. For me, it has always been a dream to help people in any way I can, and I felt like being a lawyer is one of the best way I could assist. So I was very driven all through my career so far, as being driven, knowing that I want to help. So I always look for ways to help people. So I have been an attorney at law for almost 9 years now. I've been involved in law for over 10, and I love what I do. I love helping people. I love solving issues with people, bettering their life through the law. So my career started at the chambers of the Attorney General, and I spent a few years there. Then I went to the DPP, Director of Public Prosecutions. Then I went to the Legal Aid Clinic, spent a few years there. And then I went back to the chambers of the Attorney General, spent a few years there. And thereafter, I got the opportunity to act as the deputy registrar of the High Court. And since I have been acting, I will say that I have enjoyed being able to help members of the public, meeting people, listening to their issues. I also enjoy my role with assisting in the court administration. And so far, I enjoy the staff, the conversations we have. Some of them are very much, I would say, enthusiastic to law, and they want to learn more and they want to do more. So far, yes, just enjoying every day and taking it one day at a time. Thank you.
Okay. Now, Permanent Secretary, we have not heard that from you as to how long you have been associated with the ministry, and whether you're a lawyer or not, or what do you do as a professional inclination?
I am an attorney at law. Mm-hmm. I have actually been called to the bar for a whopping 16 years now. Mm-hmm. Which is, of course, a senior attorney. And if you notice from the other ladies, Honorable Minister, you will see that the common thread is that we've all worked in many offices, mm-hmm. and we ended up in administration. I myself, I was at the Aegis Chambers. I was very briefly at the DPP. I was acting companies registrar for something like a year. I worked at Legal Aid, which is my private passion and love. I absolutely love Legal Aid. And then I became the Deputy Registrar of the High Court, another area that I love. I love registry work. So I've been an attorney for quite a number of years, and I've worked in many offices. So I've had the opportunity to work with many of the people who are now, my staff, so to speak. I have been with the ministry for another whopping almost 8 years now. I came in 2017, and I came in very early in 2017. I will never forget the date, the 1st of February 2017. And so Hurricane Maria was my baptism by fire, so to speak. It has been one of the most challenging and rewarding things that I've had the opportunity to do. You get to touch so many lives. You get to assist with policy. You get to meet amazing people. And, this job, administration, is absolutely my passion. And I know that this is my life path. This is what I want to do, even though I may not necessarily remain in one area. But I know that administration mixed with law is what I want to do for the rest of my life.
Okay, so all of you have a passion for the work in which you do, and I think that is remarkable. But let us go to the fundamentals of what we will be discussing here tonight. As I've said just now, and those areas that we are going to touch on tonight can be very controversial areas. Vexing issues emerged among family, and when people die, especially interstate, and some people do not know their rights. And when there's a will as to the various elements you have to go through to get the will probated. Let us just start maybe to look at the simple definition of what, when we say probate, letters of administration, what do we mean?
Okay, so I will begin. Grant of probate is a grant of representation that is applied for after a deceased, somebody dies with a will. So if a person dies with a will, then an application would be made to the registrar for a grant of probate. The will would have to obviously be a valid will. So there are certain requirements which need to be fulfilled in order for the grant to be issued. A grant of letters of administration is normally applied for where a person dies without a will, intestate. The property is distributed in accordance with the Intestates Act, Chapter 903 of the Laws of the Commonwealth of Dominica. So, if a person dies without a will, then an application for letters of administration would be applied for.
Okay. Well, thank you. Before we go to maybe to talk about, if at all, the similarities between a will and letters of administration, maybe we want to look at as to the actual execution of a valid will. And I'm not sure which one of you, I think that is you again, Ms. Sebastian.
Yes,
okay.
Mr. Minister. Okay, so we have a Wills Act in the Commonwealth of Dominica, and a valid will must be in writing. So that is one of the first requirements. It must be signed by the testator at the foot or at the end of the document. This document, the will, has to be signed in the presence of 2 witnesses. So that is essential. And the witnesses must be present at the same time while the testator signs the will. The testator needs to be of sound mind in order for the will to be deemed valid, and must not be influenced in any way. There must not be any sort of fraud involved in the preparation and the signing of the document. The testator needs to know the gifts that they are given under the will. They need to know the persons who they are gifting any items to. So they need to have a sound and clear mind when they are preparing the document, or the will may be subject to challenge.
Okay, that leads us to our next very important point, and in a sequential manner. Insofar as somebody were to make a will, let's say 5 years ago, and subsequently thereafter the person is not a sound mind. And we have seen in the past where that those issues have emerged very sadly. Now, what are the challenges that can be brought in terms of challenging the validity of a will?
Well, more than like this would happen like after the person has passed. So normally you would have evidence from doctors, the persons who would have witnessed the signing of the will. Yeah. If any other persons who may have had interactions with the testator may be called upon to give evidence. Most times, the challenge would be obvious in the court, and these persons would be called upon to give evidence as to the mental state of the deceased person when they prepared or signed the will.
You want to add to that, Pierce?
Yes, not forgetting the doctrine of periods of lucidity. So
Right.
this is an area of law that can indeed get very technical. So the first thing I wanted to point out was that it's not always clear-cut that a person was quote-unquote not of sound mind, because that can mean a lot of things. And there are cases where if the person had sufficient periods of lucidity, that the will would still be deemed valid. So that is another thing that you should pay attention to when talking about wills generally. It's really not clear-cut as to whether or not, unless if the person just had complete periods of not being lucid, etc. Certain things, of course, lend to that. So if I'm a cancer patient and I've been on a prolonged treatment, all of these things can lead, to challenges. So the doctrine of periods of lucidity can also play a role when you're talking about challenges to a will.
Okay. Is there anything you want to add, Ms. Sebastian, to what?
No, I agree with the PS that it's a bit technical and sometimes very difficult to prove these type of issues. So that is why the court would rely heavily on the evidence of doctors and so on who may have seen and treated the testator, before their passing. So it is indeed very technical and sometimes not very easy to prove.
Now, the next area where I think we need to amplify a bit for the edification of the listening public is the issue as to why are grants required? Why are they needed in the first place?
Okay, so grants are required for a person's estate after they die, and that is for legal and administrative reasons. And there are a few reasons. I'll point out some of them. One is the authority to administer the estate. So a grant of representation, which is a grant of probate or a grant of letter of administration, gives the executor or the administrator legal authority to deal with the deceased person's estate. That includes like assets, paying of debts, distributing of the estate according to the law or the deceased will. That's in the case of a probate. Another reason is for the protection of assets. The grant provides protection from financial institutions, government bodies, and other parties when dealing with the deceased estate. It ensures that those who receive payments or transfer assets from the estates are doing so legally and with proper authority. And that is something that is very important. Another is clearing of title. And what I mean by that is like for assets such as property or investment, a grant may be required to transfer ownership to the beneficiaries or sell the assets on behalf of the estate. And that usually helps with clearing of the debts of the testator or the person that have passed away. And also this includes ensuring that titles are transferred and done so legally and they are becoming legally binding. So next thing is resolving of disputes. In cases where there might be dispute among family members, creditors, or other interested parties, having a grant in place helps clarify who has the authority to manage the estate and resolve any disagreement that may arise. Another is the legal requirement. In Dominica, obtaining a grant of representation is a legal requirement to administer an estate, especially if the deceased has left behind a significant amount of assets or property. It ensures that the estate administration follows established legal procedure and protects the interests of all the parties involved. So in essence, obtaining such a grant of representation, is crucial to facilitate the orderly and lawful distribution of the deceased person's estate, ensuring that their assets are managed and distributed according to the law, and their wishes or the wishes of the deceased is distributed according to that, if they are known. Thank you.
Okay. Thank you. If anyone wants to add anything, I think Ms. Toussaint was very comprehensive here. Now, another area that I think we need to touch on as we talk about grants, and to whom and where applications for grants are to be made.
Okay, so in Dominica, the applications and making of grants, it's governed by the Eastern Caribbean Supreme Court Non-Contentious Probate Rules, Probate and Administration of Estate Rules, 2019. And these rules set out the procedure, the forms required, and also who, when you can make those grants. And any questions or any of the aspects of getting the grant, it is written out under this particular law. So when you look at that particular act, at Rule 5, it says that an application for a grant of probate or letter of administration shall be made to the registrar of the High Court and shall be filed in the registry, where all caveats, warning, citation, acknowledgement of service, and notice of application under the rules of the court, which is the non-contentious probate rules, where they are filed. So this is actually provided for in the law, and that's the only way someone can make, only place and where someone can make an application for a grant.
Yes, well done. And the other area we want to look at is an area where controversy sometimes emerge insofar as it relates as to who can, okay, and who can make application for grants of probate or letters of administration. That is a very serious matter there that we need to ventilate clearly to the public.
Yes, that is correct. Also, luckily for us, the non-contentious probate rule has also made provisions for that. That is Rule 6. And it says that it is made through an attorney. That is one way. Most people usually go to an attorney to help them with the system as to doing the forms, the filing. And also it can be made by the executor of a will. It can also be made by a proposed administrator. That is someone that is benefiting from the estate, and that is usually based on priority. And also, with that being said, that is really the 3 ways that a grant is usually applied for. So you must have a level of interest or be of your part of your profession as a lawyer to make that application on behalf of the parties.
Okay, as we speak about interest, and if you were to actually qualify that, in terms of, to the next, we'll talk about minority or life interest. Do you want to amplify that a bit?
As to which part, the minority or life interest? Or
Yeah.
Okay. Registrar.
Okay. Okay, so the minority and the life interest, they're dealt with in the non-contentious probate rules that Ms. Toussaint referred to at Rule 12. Now, minority interest is basically where there are children involved, and a life interest where there is a spouse. So in those cases where sometimes there are issues, or in order to protect the rights of the children or the spouse, 2 persons are required to apply for a grant in those cases, and that is found at Rule 12, as I said, in the non-contentious probate rules.
Well, it takes us as we want to do it in a sequential manner, so anybody listening can actually follow. And so who can apply then for probates and letters of administration? I
think Ms. Toussaint dealt with the The probate.
Yeah, let us go back to it and just break it down a bit as to how to apply, how the process.
Why would you like to start?
Well, okay, how a grant of probate is applied for, that too is found in the rules. So basically, the rules are very comprehensive and deal with basically all the different issues that and processes that are required for grants of probate and letters of administration. The applying for a grant of probate can be found at Rule 8 of the rules, and is normally applied for by an executor. So an application is normally made by the executor. The application form is also found in the rules at Form P1. These forms can be found at the back of the rules. Normally, a certificate of search is required. So, persons intending to apply for a grant of letters of administration or probate would first visit the registry and request that a search be done to find out whether any other grant of probate or letters of administration have been issued. The certificate of search would also indicate whether there are any caveats which have been filed. So that's it in terms of the certificate of search. Then an oath is required as part of the application process for a grant of probate. The oath can be found at the back of the rules. As I mentioned, all the forms required are at the back of the rules. In the oath, the person will indicate their entitlement to the grant. They will, the form also will require them to indicate the gross value of the estate. The will also have to be provided, and that will have to be marked by the executor as well as the person who, one of the witnesses who witnessed the signing of the will. A declaration would also have to be provided. So all these documents that I'm mentioning, these are documents that are required in order to file the application. So it's not just an application, but an application with a variety of supporting documents are required. The value of the estate will need to be established. So valuations of different property that the person has would have to be noted. Any bank statements would also have to be included. There are also some affidavits which may be required. Not in every situation they are needed, but in some circumstances, if there is a delay in applying. So according to the rules, if an application is made more than 3 years after the death of the testator, then an affidavit of delay would be required. So that would form a part of the application. If there are any variations in the deceased name, then an affidavit of alias would also have to form a part of the application. I'm not sure if there is anything that I forgot. So that is basically the application process for Probate. Oh, the death certificate. Thank you very much, Ms. Tuse. That is one of the most essential documents that's required. So the death certificate would have to be provided. There are certain circumstances where a death certificate is not available for one reason or another. If the person died suddenly and the matter is before the coroner's court, and a death certificate cannot be issued at the time, then proof of death, let's say a death card, may be submitted with an affidavit explaining why the death certificate is not being submitted. So I think that's it now. I think I've covered.
Okay.
Minister,
Yes.
if I may, one of the things that jumped out at me was the affidavit of delay. And I kind of wanted to zoom in on that and hone in on the point that you are not afforded the ability to drag your feet when you have been placed in that type of fiduciary duty. And I think I want to highlight to people that a will should not be sitting at your home when you are the named executor or executrix for 5 years, 10 years, depriving the creditors, depriving the persons who are to take the property for a lengthy period of time. That is why you have to say to the registrar, I delayed in excess of 3 years because of X, Y, and Z. The typical and ideal time is within the first 6 or 12 months to do what you need to do. I know that there are people who have wills sitting at their home, and I kind of wanted to hone in on the affidavit of delay and the reason that it is there as part of the procedure to show and highlight the importance of that duty when it is given to you.
Yeah, that's a very important point I wanted to get to. So, matter of fact, when we were speaking, I think yesterday, I think I spoke with Ms. Tusen about this very important matter, not only as it relates to executors, but the administrators also.
Yeah, absolutely.
And I am happy that you make a distinction between when the executor is a male and a female, different. We always say executor like
Executrix.
so that's
female,
that's
yes.
female, right?
Yes.
It's important for us. Right. No. But everybody say administrator, executor, what is it? And it's always important to legally qualify those things. And I was raising the point as to there's not a legal mandate to per se now to place like a time limit on an administrator. I think there's a practice of maybe a year on the common law or something like that.
The ideal time is 6 months to a year.
Yeah.
That's the ideal time, because when that time runs, then even in certain situations you can begin to accumulate even fees, even taxes, etc. on certain things. And so I think I really want to make the point that if you are a named executor or executrix and you don't know what to do, then go down to the legal aid and get some advice. But by God, do the duty that the deceased felt that you were fit to do.
I think that's a very important point, and that which actually we need to actually amplify here tonight, in the sense that if you apply for letters of administration or you happen to be an executor on somebody's will, that you are to carry out the instruction, one, from the person making the will, or from the state in the case where it's what the courts actually issue that letter of administration, that you are to execute the instruction in a timely basis. And I think that is important for us to note.
Yeah. If I may add something, one of the reasons that it is very important to administer an estate is because you do not want the asset to depreciate to a value where it's not worth anything. Because when that happens, it's at a loss to the beneficiary, who could be minors. So it's also important to apply for the grant within 3 years, and also to administer the estate as soon as you get the grant. Because as the executor or the administrator, you can be held legally accountable to produce, to say why.
No, I would like you to say that a little louder, because somebody just sent something on Facebook and the person saying she wish other people were logged on Facebook because the information is so instructive and important. So I would like you to to speak a little louder.
So there is a reason.
Repeat that,
There is a reason why you take an oath. The oath in the application of a grant is very important. back before the new rules were passed, it was an oath with a bond.
Yeah.
And the
Right.
bond had a value
recall.
in there.
Yes.
That was double the amount of the estate.
Yes, that's
So
true.
if you are brought before the court, you have to pay that amount. So you have a fiduciary duty as an executor or as an administrator to the beneficiaries of the estate. So you need to ensure that your duty is fulfilled, and one of your duty is ensuring that the estate is administered or distributed as soon as possible, because you would have to give an account if you are brought to court what happened and why is the estate now at nil when the estate was probably $250,000 or more. So it is very important that persons that have a will or persons that have to administer an estate, that they go forward with it, because it's already a difficult thing to do. You are going through, especially family members that are affected, you're going through grief. There are things that you have to put in order. Let's say you have a mortgage together and the person passed away and you need to refinance that loan. You need a grant. You need certain documents to help you to do that. When you are not doing that, you are putting yourself under financial strain, and people need to understand that. Move fast, because time have an effect on cost. Makes you pay more fees when you're making the application. Also, by the time you do get the grant and you do administer, you may have to pay fees for like interest, or probably things to, like if there is a building and it has repairs. So it is very important that a grant is obtained in a deceased when someone dies, because if not, it creates a lot of, sometimes it could even create friction in the family. So you want to avoid all of those things. And my advice to anyone that's listening, tell a friend and a friend tell a friend that you need to do your duties, and you need to go to court and file your grant.
Okay, I
File
think
the probates.
yeah, you have been doing so well tonight. I think we need to take maybe a couple seconds, a breather, and maybe you can zoom in when you come back on the order of priority when this is left behind a will. Is that okay?
Yes.
Okay, thank you very much.
To Legal Affairs and You on Thursday, June 27 at 8 p.m. The discussion will focus on probates and letters of administration. Learn about application for grants of probate, execution of a valid will, distribution of estate, and more. 8 p.m. this Thursday on DBS Radio, hosted by the Ministry of National Security and Legal Affairs. Know your rights, know the law, know your ministry, know your procedures. Tune in to Legal Affairs and You on Thursday, June 27 at 8 p.m. The discussion will focus on probates and letters of administration. Learn about application for grants of probate, execution of a valid will, distribution of estate, and more. 8 p.m. this Thursday on DBS Radio, hosted by the Ministry of National Security and Legal Affairs. Know your rights, know the law, know your ministry, know your procedures.
Okay, we're live again. Let's come back to the next matter that we want. I think that needs to be ventilated also. So I'm not sure who want to actually speak to the the order of priority where the deceased has left behind a will. Who wants to speak to that? I think it is
Okay, if a person leaves a will, the executor would be the person who would apply for probate. If the executor is not available, if they are unwilling to act, or if they are deceased, then a beneficiary of the will would be next in line. Now, this would come into play where an application for letters of administration with will annexed. This is the application that would be applied for once there is a valid will. If the executor is deceased, unable to or unwilling, then one of the beneficiaries would apply, and if they are not available, then someone appointed by the court. So this is the order of priority. If the executor is available, then an application for probate would be made. If the executor is unavailable for whatever reason, then an application for letters of administration with will annex would be what would be applied for.
Are there other areas you want to qualify in special cases?
In special cases, like I don't know if you could expound on the question. Sorry.
If you're talking about order of priority, you can maybe qualify the different.
Well, normally it would be the executor who would apply, and the executor is normally named in the will of the deceased. So that is the person.
So that's your most ideal. That's the
That's
highest
the person
priority.
who would apply. You could have one executor. You could have more than one executor. If one executor dies, like you have more than one executor and one dies, then the others would be able to apply. But it would be the executor who would apply once they are available.
Okay, fine. Okay, we try to bring out as much information as possible so that the public can benefit. But if you want to call and you want to ask a question, we have a few more minutes remaining there. You can do so. The number to call or numbers to call is 1-800-327 or 448-3284. And of course, we're speaking to the Permanent Secretary in the Ministry of Legal Affairs, National Security, and Legal Affairs, and the Deputy Registrar General, acting, and also the acting Registrar General. Now, in terms of the fee structure, do you want to
okay, so the fees are contained in the High Court Proceedings Fees, SR&O 41 of 2018. So this document and all these these acts that we refer to, and the rules and so on, all of them are available on the Government of Dominica website under Laws of Dominica. So they can be found there if anybody is interested. Then these laws, these rules, everything, they are on the government website and accessible to the public.
Tell them the full website.
So you may want to
tell them the website, www.dominica.gov.dm. And if you have never been on the site, you should visit it. There's actually a new interface. I'm sure you've seen, Honorable Minister, there's a new interface. It looks a lot more modern, and it's just really cool right now. So you can go to the area called laws, and you can engage the search engine to look up the laws. Dominica is one of the few territories that's fortunate enough to have our laws online, and that will be updated very soon in terms of the new 2017 update of the laws. And in terms of some of the matters that may put into protocols, etc., they would also be available on the EC Court's website. So you do have that avenue as well if you want to keep up to date with some of the protocols, etc., and procedures that would influence things like probates as well.
Maybe you want to go over it again slowly. So
sure. Okay. So the Dominica website, where you can pretty much find information on everything, www.dominica.gov.dm. and you simply go to the tab called Laws, and once you click on it, you will engage a search engine and you can search keywords to find whatever law that you're looking for. It will not only give you the acts, but it's going to give you all of the updates. It's going to give you the ordinances as well as SR&Os related to that piece of legislation. So if you want to look up the laws of Dominica, if you want to go and test the veracity of what you hear and you want to know, you want to learn your country, that website is a really good place to go. I must congratulate the government on that website. It has a wealth of information.
And as you know, the ministry has been leading the way in actually making it easier for the public to access information.
That's right. And as well as the eccourts.org. Am I correct, ladies? Yes. The eccourts.org, you can also find a lot of information pertaining to the various islands, and that includes some of the probate rules as well.
Miss Sebastian, you were saying something.
No, I was asking whether you wanted me to go through maybe the most pertinent fees.
Yes, I think,
Okay, so the applications for probate and letters of administration, there's $100 fee attached to the applications. Every affidavit which is filed is also $100. The declaration as to the value of the estate, which is the document which lists all of the assets of the deceased person. So this document the fee is $1,000 for the declaration. The order that would be obtained if the grant is accepted, it's allowed, is $100, and the actual document that you get at the end of the process, what we call the grant of probate or letters of administration, it's also $100. Every certificate, birth certificate, death certificates that are filed, the fee is $10. Miss Tuse just reminded me that all filings for probate and letters of administration, they are done through the ECSC e-litigation portal. So so all filings can be done online, so lawyers don't come in to the registry to file the applications for letters of administration and probate. We have a service bureau at the court that deals with in-person self-represented litigants. So in those cases, they would actually bring in the documents, and the staff at the registry would file the documents on the portal. But lawyers representing persons they file it from their offices. And for every document filed, there is a $2 administration fee that is added to the fees that I would have just mentioned. So for all of the fees, so the fees that persons, if they go online to look up the fee schedule on the website, as we mentioned, they would see $100, $1,000, $10 for the documents. But when they're actually filed, the fee is plus $2.
Okay. So we're now 15 minutes after 9 o'clock. We're getting there. I think we wanted to touch on an area, in areas or in instances where you have small estates, small estate grants, where the value of the estate is $5,000 or below. Do you want to say anything about that? Is there anything in particular that you want to actually reference?
Except to say, well, the usual documents that are required for an estate of a higher value, they are not required in this case. Generally, it's the documents are brought to the registry, and the staff would prepare the documents. Each document that is filed, the fee on the portal is $2. And you basically need the death certificate of the deceased, birth certificate, a marriage certificate of the person applying, a document indicating the value of the estate, and proof of the identity of the person applying. So quite a few of the other documents that are required where the value of the estate is more than $5,000 are not required in this case. It is important to note that the other applications are dealt with by the registrar or the deputy registrar, but in this case, in the case of small estates, the application is approved by the judge. So it would not be, well, the registrar, the deputy registrar would make a recommendation to the judge through what is called a registrar certificate, recommending or not recommending that it is granted or whatever, but it is the judge who would essentially approve this application.
Okay, you all have done a remarkable job so far as we are getting closer to the end of this very informative program. I'm hoping the next time we come, we'll be actually putting focus on something I think the public will also benefit immensely from. I know tonight the information that you put out here tonight benefited the public. But as we're about to leave, I maybe want to get from you, as a practitioner doing the work, what advice would you have for people or lawyers applying on behalf of the clients to make it easier for you to execute your function?
Well, for us is when you file the application, ensure that all of the documents and fees are paid and all of the documents required for the probate or the letter of administration, whatever grant you applied for, is on the portal. Because that is what that caused the delay. We would review the file and we will find things are missing or they were not done properly, and we would have to put something on the portal called the registrar's comments. And the lawyers now will have to go ahead and fix these documents or provide us with certain documents that we'll need to satisfy us that the grant can be given to that particular individual. And then the duty now falls on them to call our clerks at the probates desk to inform us that those changes and or amendments has been made. You have anything to add, Registrar?
I would just like to add that with the e-portal, it is very important that persons review the documents that are scanned before uploading them to the portal. Sometimes the documents that are uploaded are illegible. They are dark. Sometimes half of the page is missing. Sometimes pages are just, the complete document is not there. Sometimes the wrong documents are filed. And I think all of this is because sometimes the documents are not reviewed before uploading. So you scan the document, but you need to ensure that the document that you are going to file is in proper order. Yeah. So I think it is important to scan, but review the document that you scanned before uploading and filing. Because, I mean, something it's a waste of money because it has to be done over.
And I think one of the things with moving into the e-litigation system portal, which we're very proud of course, is that when you're dealing with electronic systems, they have their own sensitivities. And sometimes the things that you might have been able to get away with hard copies, the system is simply not even going to allow you to proceed any further if it can't read a document or if it can't, compile a document, etc. So the double-edged sword with all this little stuff that we're doing, which of course is a good thing and is the ideal thing for all of the islands, is that you have to now be a little more accurate in terms of the quality of documents that you submit. And my advice, of course, to attorneys would be that if you are in doubt about how legible it's going to be, perhaps you can have a bilateral with one of the registrars so they can assist you with determining the quality that you have.
And one of the safety features of the portal is when you upload the document, it does not automatically just approve. You still have a second opportunity after you upload it to download what you uploaded and view it and make sure it's in the proper form, it's legible and it's the right document and also titled or named properly. So don't say it's a death certificate and you attach a marriage certificate or death card. So it allows you that safety feature, and then after you can submit when you are satisfied and sure that it's the right document in the right way.
Okay, at this point we maybe want to take your closing comments as it's now 23 minutes past we have to end at 9:30. So are we going to start firstly with Ms. Tuse?
Yes, I would like to thank the Honorable Minister for having me on tonight to share some of my knowledge as it relates to probates and letter of administration. I hope the members of the public, both in Dominica and abroad, who will listen in, have learned something and understand the importance of getting your property or the property of your loved ones probated or a letter of administration. I would also like to acknowledge our staff at the registry, Miss Vashanti Lewis, who has been very, very helpful on the probate desk. We also had Miss Tricia Japier, who would assist her, who was also a probate clerk, and Miss Kishma George, who also assists. I am very grateful for my probate desk staff. I think they do an awesome job, and I think they help the public to the best of their abilities. So with that being said, thank you very much.
Ms. Sebastian, Registrar General.
Like Ms. Tuse and Mr. Minister, I would like to thank you for having me here tonight. This is my first time in studio.
Ever?
First time. Ever.
I can see you're looking nervous.
First time.
But you're always nervous and you're always nervous.
You did really good there.
First time. So yes, I want to thank you for having me. I hope that the listeners would have learned something, and they can, if they are ever in a situation where they need to, they are the ones who are applying or they are involved in, the process. I mean, we all have to go through these type of situations. So I hope that they are more knowledgeable based on our discussions here tonight. I would also like to thank the staff of the registry, the probates and letters of administration section. I would also like to mention, she's no longer with us, but Miss Joanna George, who also had done a very splendid job while she was at the registry. I would just like to remind persons that the laws, the rules, the relevant pieces of legislation can be found on the government website. They can also find information as it relates to the filing of documents on the Eastern Caribbean Supreme Court website. So that's it for me, and thank you once again.
I want to actually in a special way commend you because you really managed your nerves very well tonight. Very, very articulate and you look comfortable. So you can find ways to to find your comfort zone anyway. And I want to commend you for that.
Thank
Not
you.
all of you. And thank you. Permanent Secretary, your final comments.
Thank you. I want to thank the Honorable Minister as well. This the idea of the radio program for the Ministry of National Security was the Minister's brainchild, and I think we're doing quite beautifully on the programs. They've all been so informative. As we continue doing these sessions, I hope that we get to indicate to the public that, one, you are governed by laws, and so you should not be shy about finding out the laws that govern you. So I hope that tonight we've encouraged you to actually go online and look at, whatever is affecting you at this point of time. If it's probate, then that means we have been quite on brand. I want to congratulate the two ladies here with me. Kyan especially is relatively new in her role, so I'm quite impressed. But I have every confidence in her. Naya, I mean, I've known both of them for so long. I also want to give a little shout out to our outgoing registrar, Miss Marie-Therese Etienne, who has, left us permanently this time, but to whom we're very grateful and who did a fantastic job during her tenure at the registry. Like I said again, I do want to encourage people to tune into these programs if you can, and to listen, and you can even make notes, because I actually made a few notes, even though these are areas that I'm familiar with. And I hope that you continue to grow with us as we continue to grow our program. I will most likely be on again because I am the PS, and I will be coming back for other key areas. So I'm really pumped about doing another program very soon, Honorable Minister.
Okay, you're most welcome. But let me just again thank all of you for being here tonight. I think you have demonstrated to the highest level your commitment to your job and to your country. Most importantly, you've been here tonight. You could have been somewhere else within your own comfort zone at your respective homes. But again, we will continue within the ministry to do what we have to do to inform and to educate. So the next time we meet would be the second Thursday of next month. Yeah. We'll be talking on yet another very important national topic. So have a nice night, ladies.
Good night. Thank you very much.
Good evening to our wonderful listeners. And stay tuned to your number one station, DBS Radio.